How common is the problem the first problem that you mentioned of not being scrupulously honest in the characterization of what the lower court has done?
It's never a problem with the SG. Even if I disagree with the argument, I know that the brief will give an honest count to the authorities. That's very important. I know I can trust the SG's brief. And especially in a court like this, or any federal appellate bench, a lawyer who slants an authority is going to be found out. I mean, there are all those law clerks who are here to ferret out those exaggerations, misrepresentations. So be honest, I think, is number one rule.
In a speech you gave recently, you disdained 3-prong and 4-prong tests. What's wrong with them?
Well, 3- and 4-prong tests are, I think, a clue that a law clerk's work is behind that. 3-prong, 4-prong, that's law review language, and sometimes it doesn't make a whole lot of sense. It gives a false sense of security that you have to go down this litany of 1, 2, 3, 4. But often the decision is made on other grounds and then fitted into these prongs.
In a piece you wrote about a decade ago in the Georgetown Law Journal, you said that law review writing is often in a language that ordinary judges and lawyers don't understand. Why is that a bad thing for legal scholarship?
Well, if you want to write a piece on philosophy, that's fine. But if you're trying to write for a lawyer or a judge as your consumer, if you're commenting on a body of precedent, or it's a statute that you're trying to parse, you really do want to be clear. You don't want to be operating at a high philosophical plane. Judges are not going to read those articles because they haven't got the time to try to penetrate them.
Has the balance swung too far in favor of that kind of philosophical, difficult to understand discussion?
There's still so much good writing. For example, in my own field, I taught procedure, civil procedure. If I have an article by, say, David Shapiro, I mean, it's just a godsend because it's so bright and so clear and just enormously helpful.
You admired Charles Allen Wright's style
Yes.
a lot.
Yes.
What did you like so much about Charlie's writing
For
style?
one thing, he was clear, he was assertive, he didn't have any fear about saying something straight out. He didn't feel any need to qualify things because, well, maybe I'm wrong. And he had a wonderful sense of humor.
Does that show through even in his treatise and
Yes.
his Horn book?
Yes, I think so.
On occasion you've referred to dense statutes. Is density unavoidable in legislative drafting, or is there a better way?
Well, it may be that too many cooks spoil the broth, because some of the bills that Congress deals with tend to get cluttered with special interest exceptions here and there. There are systems, legal systems, that have expert committees draft the law in keeping with the guidelines set by the Parliament. I know Sweden is a country that operates that way, so its legislation is more professional than ours is.
Do you continue to learn things about writing yourself?
Oh yes. Oh, I just read a wonderful article by Judge Laval in the Second Circuit. It was his Madison lecture at NYU, and it's about the distinction between holding and dictum, and how dangerous it is to be sloppy about using the word hold. It's delightfully written, and I am certainly going to pay attention to that. I'm always learning about writing. I read and admire someone's writing and say, that's a good way of putting something.
Have there been any writers outside law been major influences on your style, apart from your own teachers, Cushman and Nabokov?
I can't say that there's a direct relationship between Jane Austen's novels and my writing, or, let's see, or Tolstoy. I'm thinking of writing, or
Let's talk about Jane Austen for a moment. What do you admire so much in her novels?
the word pictures that she paints. It's not really the plot that counts. There's a certain sameness to them, but it is, she is like a painter with her pen.
What about Tolstoy?
But he's very strong. He's a strong writer. He's a contrast to Jane Austen in that respect. But I remember the first time I read War and Peace, I was 16 years old, and I couldn't put it down.
So is a lot of your extracurricular reading the classics?
It's eclectic. It's mainly with my husband. He's a voracious reader, and he knows how little time I have, so he will say, this one is really good, this one you will enjoy. The problem is, when I read a good book, I want to continue, and I know I have to put it down and turn to the not-so-beautiful briefs.
Does reading briefs all the time sort of, is there a problem if that's all a judge is reading?
Yes.
Having that infect your style a little bit? Do you have to inoculate your style against some of these bad habits that you see in briefs?
Well, you need a respite from the briefs. There's no question about it. You can't have a steady diet of them. So my respite is, for example, the Washington Opera, whether it's a performance or a dress rehearsal. And we have some timeouts at the court as well. We have annual musicales. In fact, this year we're having 2 of them. So, yes. What is it, all work and no play makes the judge a dull person.
If we exclude present justices, who, in your opinion, were the best writers ever to sit on the Supreme Court?
If we could start with John Marshall, then probably just the best writer is Holmes. In more recent times, the second Justice Harlan, because he laid it all out. You could agree with him or disagree with him, but you knew every step in his reasoning. Nothing was hidden. Nothing was shoved under the rug. Brandeis was a very fine thinker and writer.
Do you admire Jackson?
Oh, yes. He is also a wonderful writer. Yes.
What is your view of legalese?
It's like any profession has its jargon. The sociologists have lots of fancy words, and they think somehow that puts them on a higher plane. I can't bear it. I don't even like legal Latin. If you can say it in plain English, you should.
Is there any problem with professions having their own sort of in-speak?
If you want to communicate with the public, you don't need to do that. There have been movements about using plain English in contracts and wills, and those movements start with great enthusiasm and sort of fizzle out.
Do you think it would be a good thing if lawyers everywhere became more dedicated to trying to use plain English?
I think it would be a very good idea, yes.
How would that affect the legal profession?
For one thing, you'd have much shorter documents than we now do. For another thing, the public would understand what lawyers do, what judges do better. They might understand it even from reading an opinion or from reading a brief, instead of getting it filtered through the lens of a journalist.
Should judges at all levels care whether ordinary people can understand their opinions?
Yes, with this caveat, to your first audience, if you're an appellate judge, it's other judges and lawyers. And after that, well, when I describe my, what I call press release opening, that's addressed to the general public. I hope that in most cases, what I write is clear enough for a lay audience.
But there must be a way of satisfying the experts, satisfying the lawyers and judges and law professors, and at the same time making it accessible to the general
yes,
public.
But some parts of opinions, you really can't. If you're trying to explain the fine points of say a provision in ERISA, there's no way you're going to be able to do that. To make it clear to the non-lawyer.
What kinds of things in briefs that we haven't spoken about commonly annoy you?
First, excessive length. Second, well, I've already said about honesty in brief writing. Oh, something else. It isn't necessary to get your point across to put down the judge who wrote the decision that you are attempting to get overturned. It isn't necessary to say anything nasty about your adversary or to make deriding comments about the opposing brief. Those are just distractions. You should aim to persuade the judge by the power of your reasoning and not by denigrating the opposing side.
Do you have a sense that lawyers everywhere have heard that ad hominem attacks don't work, and yet they always tend to think, well, this case is the exception. I've got to let the judges know just how bad the other side is.
If the other side is truly bad, the judges are smart enough to understand that themselves. They don't need the lawyer's aid.
So better to be dispassionate.
Yes.
About that.
Yes.
What's the most important part of a brief in your view?
If you're on the petitioner's side, to anticipate what is likely to come from the respondent and account for it in your brief. Make it part of your main argument. You know the vulnerable points, so deal with them. Don't wait to say for the reply brief. Just incorporate in the main brief as part of your affirmative statement. answers to what you think you will most likely find in the responsive brief. And in the responsive brief, I think the principal danger is that it will end up being a series of not so. The petitioner says thus and so, or the appellant says thus and so. That's not so. A series of no's doesn't really work. In the days when I was writing briefs, I tried to draft a brief for the appellee or for the respondent before I ever got the brief for the appellant or the petitioner, because I wanted to avoid that trap. So I told my side affirmatively, and then used, for the most part, footnotes to answer the points that were made in the petitioner's brief or the appellant's brief that had not been part of the body of the brief that I tried to write even before I got the brief that I'm answering.
Do you feel strongly enough about that you could make it a general recommendation that appellees ought to go ahead and make their affirmative cases, just do a draft before they see what the appellant's going to say?
Yes, I think that's a very, very good idea. Because as I said, the principal danger where you're on the downside is to have this negative cast to your brief by saying, not so.
What would be your two biggest tips for oral argument?
First, appreciate that oral argument is not an occasion for speech making, not in a court like this, and certainly wasn't so on the D.C. Circuit. These are hot benches. The judges are prepared to the hilt, and you will do best if you concentrate on the questions you're being asked and not resent them as distracting you from your prepared lecture. In many systems, lawyers do make lectures. They make grand pleadings. And when judges from other countries that follow that civil law pattern come here, they're amazed that we interrupt the counsel. They sit there, stone-faced, listen to what the counsel says, and then they do what they want. I would much rather have a hot bench so I know what's on the judge's mind.
Do you think lawyers have a professional obligation to become the best writers they can be?
Yes, I certainly think so, both for their clients and to the extent that a lawyer is a skilled professional who has an obligation, I think, to serve the public. The more effective that a lawyer can be in speech and writing, the better professional he or she will be.
Justice Ginsburg, thank you so much for your time today.
It was a pleasure.